So I want to explain why I recently filed an amicus brief to the Washington State Supreme Court as it relates to one of the most bizarre campaign finance lawsuits in the history of Washington State. And I'm referring to the Ferguson versus Eyman death match lawsuit, which is over 10 years in the making to get this far right now. And I want to discuss the background, why it matters, and how I plan to use the Court of Appeals' absurd ruling to go after several hundred leftist activists in this state if the Supreme Court really allows this ruling to stand. So let's get into the details here. First, I want to let my viewers know that I've linked a lot of source documents below in the video description area of this video. You can go there and you can look at these documents for yourself because they are mostly legal documents that are tedious, boring, verbose, and if you're a victim of Common Core education, you may not even be capable of reading them anyway. However, some people, and I kind of include myself in this category, we like source documents, so they're down there if you're curious. Before I explain the amicus brief, which is just a fancy term for a pleading letter to the Supreme Court by someone who's not a party to the lawsuit explaining why they should review this case, I need to give a short background explanation on the Bob Ferguson versus Tim Eyman lawsuit and kind of how we got here. Now first, Tim Eyman, as most people in Washington State know, he's been known for over 20 years as the initiative king of Washington State since his early forays into the initiative process in the late 1990s. Nobody has ever qualified as many initiatives or had as much an impact on the state with the initiative process as activist Tim Eyman. At his core, I think Eyman's a promoter. He's a promoter of initiatives, nearly all of which were initiatives that cut state taxes. From car tabs to property taxes to state performance audits, this guy managed to qualify 17 initiatives to the ballot, convinced voters to approve 11 of them, and he earned the ire, the brutal anger of the administrative state along the way. If you don't believe me, look at cartoons like this that they made of him. So if Washington State had kind of a deep state swamp, Tim Eyman, over the years, he clearly identified himself as the one most likely to drain that swamp due to his tax-reducing efforts using the initiative process. So, of course, the swamp has a lot of creatures that live in it, and Eyman eventually became the target of the biggest swamp creature of them all, Attorney General Bob Ferguson, and recently announced candidate for Washington State governor. And Ferguson's an important person. So, in a legal battle that has spanned more than a decade, shortly after Ferguson was unfortunately elected to become Washington State's Attorney General, he made Tim Eyman into his personal vendetta, and he directed the full power of the state to crucify and destroy Tim Eyman's life. There's really no similar case that I've ever been able to find in Washington State history when the state has so abused the power of the state to attack, to harass, and abuse an individual over what amounts to, at worst, a paperwork error in the world of campaign finance law. The lack of proportionality in this case is particularly absurd when you realize how Washington State Attorney General Bob Ferguson, how he's done everything in his power as AG to avoid prosecuting real criminals. In fact, he has become our state's violent criminals' best friend, particularly violent sex predators. So back to this Bob Ferguson versus Tim Eyman case. It is actually called State v. Eyman, but the personal vendetta is so transparent and obvious that the only honest way to report on this case is to call it the Bob Ferguson versus Tim Eyman case, since only King 5 News or the Seattle Times can't see this case for what it is. Now, obviously, Eyman stepped on a lot of toes over the years. In fact, he's also offended a lot of politically powerful people in the state, people really in both dominant political parties, but the results of his efforts clearly hurt the grifters and the bureaucrats the most. So they were going to get their revenge. As anyone who has participated in the state's political process knows, the Washington State campaign finance laws are semi-irrational at times. They're easy, it's easy to be abusing these laws by the state, and they're often used to suppress new participants in the political process. Even longtime politicians, political parties, PACs, and judges frequently violate these laws. But the AG decided to find some reasons to sue Tim Eyman, basically based on a complaint that was actually filed against him over a decade ago. So the original complaint doesn't really matter because it was merely the excuse to use the state's subpoena power to find something on which to hang Eyman and to stop his annoying, tax-cutting, initiative ways. In fact, this is one of those situations where I would say, show me the man and I'll show you the crime. That's what Bob Ferguson said, and based on a campaign finance violation claim involving a relatively small sum of money back in 2012, Eyman got a chance to experience the full power of the state directed at him now for over a decade. Now, ultimately, this resulted in just this absurd $5.5 million fine with attorney fees included. They were imposed on him by the now retired Judge Dixon in Thurston County Superior Court. Now, this case also conveniently has a 12% interest rate attached to it, so the final amount, of course, is growing by several $100,000 a year. And because it's a fine imposed by the state, the final amount can't be discharged by a bankruptcy court. So permanently indenturing the servitude of Eyman has been achieved by Ferguson now against Tim Eyman. And so even if it took 10 years to get here, he's finally achieved his goal. Now, there were a lot of weird and bizarre parts of this lawsuit, which I could explore right now, but I expect some people are going to do this in the future. But this case has really been heard by only the Washington State Court of Appeals so far, just recently. And then Tim Eyman's current attorney is former Supreme Court Justice Sanders. And although Eyman actually kind of floundered through a variety of attorneys and even a long period of this pro se representation, which means he was forced to represent himself against the state without an attorney, I feel that his current legal counsel is actually about as good as he can get at this point in time. So Eyman recently had his case, as I mentioned, heard at the Court of Appeals, and they did three things, actually. And just to keep it simple, I've summarized this. First, they determined that the lower court erred by allowing a $5.5 million fine without allowing the bankrupted and divorced and unemployed Tim Eyman to present any evidence demonstrating how there was obviously no way he could ever repay that fine anytime in the future, despite the judge at the time saying that he could do it. They didn't allow it. So the Court of Appeals sent that back. They also tossed out some of Ferguson's absurd restrictions on free speech, which Ferguson tried to impose on Tim Eyman as part of the lower court settlement. Now, or judgment, I should say. And finally, and this is the part that I focused on, the court basically accepted and let stand what I believe to be the most absurd aspect of Ferguson's case against Eyman. And this is the part that claims Eyman, the person, Tim Eyman himself, the human, that he is a living, breathing PAC, and every penny spent on his life or given to him by anyone must be formally reported as a PAC contribution with the Public Disclosure Commission. Now, it's this issue that I zeroed on when I filed my amicus brief to the Supreme Court. And I wasn't the only one to file an amicus brief. The Goldwater Institute out of Arizona also filed one. There would have been more, I expect, but the AG did a good job threatening organizations who attempted to intervene in this absurd lawsuit, something I've never seen him do before. So I expect that this reduced the attention that this case really deserves at this point in time. Now, essentially, I'm asking the court to reconsider this lower court ruling and the AG's unprecedented fiction that an individual can, by definition, be declared a political action committee under Washington state law. Now, I've attached the amicus brief below, and you can read it for yourself. But essentially, I point out the obvious absurd fact that under these same Washington state campaign finance laws, it is also illegal to spend PAC money on personal expenses. I mean, just flat out illegal. However, if you're a living, breathing PAC by definition of the state, and you can't spend money or anyone else's money, by definition, how can you live? You can't buy food, you can't buy clothing, you can't accept free housing without further breaking the law, and then, of course, starting this insane legal cycle all over again. Furthermore, I point out to the court that this decision, if allowed to stand and exist as defined by the Court of Appeals, it means that I can use the exact same reasoning used by the AG and the Court of Appeals to redefine several hundred leftist activists all over the state of Washington, but mostly in Seattle, as living, breathing PACs by themselves. And they, too, would be forced to eventually succumb to the same level of absurdity as Eyman has been experiencing all along. Now, I know what you're thinking, Glenn. That could never happen because the rules and the law are not applied equally in Washington state. I mean, you might want to tell me that our judges are corrupt. Political animals, right? Appointed by Inslee because they're biased and corrupt, not because they care about the law. And yes, I'd have a difficult time arguing against you, but it is still important to point out absurdity when we see it. We still have to question authority when they err. We can't just look away and then think that it's somebody else's problem. Because right now, sure, it looks like it's just Tim Eyman's problem, right? It's easy to say that he's too aggressive or that he was a goofy guy who dressed in gorilla suits and Darth Vader costumes to piss off the media and kind of stepped on too many political toes. And it's easy to think that right now. And to discount this entire insane lawsuit is just something that happens to other people. But we can't all look away or run away when craziness happens. We have to be willing to stand up and confront those who abuse their power and the state to push their political agenda. If we don't do it for someone like Tim Eyman, the crazy initiative guy, right? An edge case to be sure, but still just a regular guy. If we don't stand up for him, then when will we engage? I mean, this was a personal question for me, and while I feel entirely inadequate in what little I've been able to do, I still believe that we have to push back and we have to expose the truth in all of its absurdity and irrational results. I don't know if the Washington State Supreme Court will take this appeal. They're often willing to let the little people get harmed by the state. The judges in our state do this fact every day. However, I'm certain they won't reconsider this ruling if we all sit back and then we do nothing about it. And this ruling certainly deserves to be reconsidered by somebody. There has to be some adult somewhere. We have very few options left. Now, Eyman has been personally destroyed by the state, which was, of course, Bob Ferguson and the Democratic Party's goal in the first place. Mission accomplished, because the process is ultimately the punishment in these types of cases. And driving Tim Eyman into divorce and bankruptcy, that's always been part of the measurement of success for these guys. I was told by one of Eyman's previous attorneys that they believed the state's legal actions, like attacking Eyman's family, his wife, and intimidating his longtime financial supporters, was really just an effort to push Eyman into suicide. Now, fortunately, the state didn't succeed in that goal. Tim Eyman is still fighting back, amazingly. But the other message has been sent very loud and clear to those who will hear. And the message is really this: if you try to constrain the state will destroy you, one way or the other. We've seen this on the federal level for sure, but this is what it looks like in the small pond of Washington State. And while the intimidation tactics are absurd and absolutely out of control, it is important for us to recognize them for what they are and to not forget the people involved in this abuse. The judges, Bob Ferguson, the attorneys who worked at the AG's office, and their cheerleaders in the media all at the same time. I believe in many ways that we're really reaching this apex, or kind of the pinnacle of this abuse. People around our state and really our nation, they're realizing that the instruments that we've created, the state and all of its bureaucratic appendages, that's metastasized into something very ugly, very abusive. And of course, it's very threatening and fearful to our freedom and liberty. We can't hide and pretend that it's just going to ignore us. It will not. We have to stand up and question the authority, particularly those who believe that they have the right to do this to us. I hope my little part in this process has an impact. I hope that I can help Tim Eyman get the hearing that he certainly deserves. However, most of all, I hope that I can encourage all of you to do your part in whatever way makes sense, and to share the truth and to question authority in your own way. That's actually how we make a difference. That is how we show up. And that is why we must show up, because in the end, the future belongs to those who show up.